Hello, everyone. Welcome to Court with Krissy. Burnett County, Wisconsin has brought out the CSI to investigate the poaching of a deer farm's prized trophy buck. All I can say is if Dateline covered more cases like this, women wouldn't be watching alone. You can thank me later, NBC. I hope you like it. Court with Krissy is now in session.
Are the 915s being called together or those
Yes,
separate?
they're two separate cases, but they're being called together because it's similar underlying facts.
That's the same motion.
And I believe I have Mr. Moustakis.
That is correct, Judge. Good morning.
Good morning.
And I do have my client in my office with me. I'll just turn the
Okay,
screen here so you can
excellent.
see that he's
There
here.
we go. Okay, so
Okay,
we have
but I'm gonna
Wesley
turn it back
Rail
to me.
Wolf.
Is Kelly there yet? Kelly Thompson?
I do not yet have Kelly Thompson, nor do I have Terry Wolf.
I know that she is on her way. She and I spoke this morning. She was in Rice Lake and driving towards you.
Oh, she was coming in person?
Yes.
She's in person.
And there she
She's here.
is.
Do you have Miss Wolf with you?
I believe she's on Zoom.
She's not. Oh, no, she just popped up right now.
Wonderful.
All right, Miss Wolf, I need to see you. We will go on the record in the matters 24 CF 110, 24 CF 111, State of Wisconsin versus Wesley Rail Wolf and Terry Wolf. Appearances are, we do have appearing in person, Kelly Thompson, counsel for Terry Wolf. Terry Wolf appears by video conferencing with approval of the court. We have Wesley Rail Wolf appearing by video conferencing in the office of his counsel, Albert Moustakis, who also appears by video. We're set today in this matter for a motion hearing. Both defendants through counsel have filed a motion to dismiss for lack of probable cause within the four corners of the complaint. I have responses by the state as to both. I guess I'll turn to Mr. Moustakis to see if there is any further argument or information to be provided to the court, and then I'll ask Ms. Thompson the same.
I'll just make a few points that I looked at regarding this case, Judge. I don't know that there's been any ownership of this deer carcass or the alleged deer head proven here, or I shouldn't say proven, but sufficiently shown in the probable cause section of the criminal complaint to support either charge. The owner of the deer farm, as I read the complaint on page 2, said that he wasn't sure if the deer in the picture was his. He's never been able to show any ownership. They cannot place the heads seen in the other pictures with the deer on the farm of victim 1. And there's more than that. You know, the owner said I think it was $35, and he was going to try to verify if the carcass was actually one of his bucks. So I'm not sure that that's happened sufficiently enough to connect the dots here. So I'm really concerned about the probable cause here, because when we take a look at the instructions for both criminal damage and theft, it has to be the physical property of another person damaged without consent, or the physical property of another person stolen without consent. Even though consent I'm not going to say consent couldn't somehow be inferred. There's no statement of the owner of lack of consent, but I don't know that that's a major issue. There's no connection to the head with other than a possession of a head. There's no connection that my client ever shot a deer belonging to the owner, that he decapitated a deer belonging to the owner. All that is shown in the complaint is a picture. There's some messages on Facebook, but again, that doesn't connect the necessary dots for these charges to be supported sufficiently enough in the complaint. If there were more, I might not make this argument. But the head of the deer was never produced. The weapon to match or anything to match even the alleged bullet that was in the deer. So I'm having a hard time being able to connect sufficiently enough, even for probable cause, that there's enough information to support the two charges. Relative to value, even, the owner says, I have some bucks that are worth between $10,000 and $15,000. He never references the carcass or the value of that particular deer, if in fact it's his. So I just don't know how we get by those things for purposes of this complaint. So I'll supplement my brief with those statements, Judge.
All right, thank you. Ms. Thompson?
Good morning, Your Honor. I would just echo, you don't need a duplicative argument of what Attorney Mustaka said, and I still have, it's even more tangential for Ms. Terry Wolf. I don't see where she comes to play except towards a potential phone call, possibly the fact that she was at the house and that Wesley was in the house and that they're related. I don't see any connection to her or even the alleged possible carcass or deer head. So with what Attorney Mustaka said, I think there's really nothing connecting Terry Wolf to any of this except this tangential relative. And then what Attorney Mustakas mentioned is not even connecting them to the actual deer head or carcass.
All right. Mr. Schmidt?
This is a four corners motion. We're not going with reasonable hypotheses consistent with innocence. There's mention of AI and maybe somebody else used Wesley's account. Maybe somebody else's account was confused. The evidence here in the complaint is a guy who runs a deer farm called the cops because the deer was poached. He said there were no holes in the fence and he found it in the fence. Bailey Mangan went out and saw the deer. So there is a dead deer. It exists. It's not alleged or hypothetical. He saw from a Whitetails of Wisconsin group in a DNR tip that he saw a deer that maybe was his. The cops didn't stop there and charge based on that. They got a photo of the deer when it was alive and the deer from the photo, and Travis texts on page 2, why I bolded it in the criminal complaint, says it's the same deer. He matched Wesley Wolf to his driver's license photo. He then got a subpoena for Facebook and found Wesley Wolf was sending that photo to a bunch of people online. That's in the complaint. Shows that, the deer was found on November 11th. And then we have Wesley Wolf on November 5th talking about, I Googled the Wisconsin Trophy Whitetail Farm and went to the Pierce Farm website and watched some videos. Them bucks are monsters. Gonna have to make a second run. And then later, fuck yes, you shot the baby. The only one by the fence. Again, the mention of the fence, like the owner said. Talks about calling them pagan swine, talks tons about poaching in general all around this time frame. Then he starts talking about after the police start investigating it, all we got to say is we found that head. Should we hide the gun somewhere? They'll never find it. RICO case. Bro, if I could have, I would have shot that buck 100 times. Fuck everyone. And then we also dumped his phone, but we dumped the phone after we tried to find the head at his aunt's residence. And then same day the cops went to the residence, she messages Wesley, stand tall, nephew, don't say shit, you got this. Get rid of the gun in the boots. Wesley said, gun's long gone, the gun that they're complaining we can't find. She then gives him advice, fuck them boots, get a different pair. payday or putting at Johnny's, suggest getting a half size bigger. Really just classic textbook accessory after the fact, party to a crime, helping him evade arrest. After the police come there, she gets to see the search warrant, gets to hear what they're looking for. She also lied to the police at that point too. We know from the Facebook, and that's also in the complaint, that he did send that to her. She saw it before the police went there, and then she said, "No, I've never seen that deer before." So the consciousness of guilt, the direct physical evidence. We have a photo of Wesley holding the head of the deer, and the deer has been matched, is there. When the complainant first called the victim, the police, he said, I saw this here. It might be my deer when he first made the complaint. And they checked later and confirmed it was just the same as, someone might call the police. "Hey, I saw some pry marks on my door. I think someone might have tried to break in." The police investigate later and confirm if someone broke in. That doesn't mean, well, they weren't sure when they called it. So maybe there was no burglary. Bringing this all back, what's the standard? Standard isn't there a reasonable hypothesis? Court should weigh them. No, it's not. It's a test of minimal adequacy. We're looking at whether there's technical deficiencies in the complaint. We're not talking about speculation of, oh, maybe it's not his deer, maybe it's AI, maybe it's the Facebook is fake, maybe someone else used his phone. All reasonable inferences drawn in favor of the state. Probable cause here. Thank you.
All right, any rebuttal?
Your Honor, I'll let Attorney Mistakis go first.
The first comment I have about what the state has said is he said somewhere that they confirmed that the head belonged to that carcass in the complaint. I'm sorry, but I don't see that. Maybe the assistant district attorney, the district attorney can point that out to me, because I've read this complaint more than once and I never see any statement by anyone that confirms that the head in the picture was the head to the deer on the ground. And
It's
now
the
I've heard the
bolded-
statement more than once. I heard it in his brief, and now I hear it on the record, and I certainly can't find it.
It's the bolded sentence.
I've read it too. We'll get into it. Nobody needs to go back and forth. I'm just hearing any rebuttal because I pretty much read the complaint myself 5 times. So go ahead.
Your Honor, I would just say, based on what the Assistant District Attorney stated, that again, Ms. Wolf allegedly made some text messages on a phone. I don't know if she's been even connected to that phone. And again, this happened days after the theft and the criminal damage to property. If they are charging obstructing an officer or some type of tampering, that's one thing. But the criminal damage to property, party to a crime and theft, I don't see where Ms. Terry Wolf is involved or the state can even meet the most minimum burden.
Now I'll turn to the state for that particular argument. As to the deer argument and those arguments, I don't need any further response.
Sure. As I said, my initial argument is party to a crime. She's actually lending aid and assistance, giving him tips on how to evade law enforcement based on what she learned from the search warrant. The getting the larger size boots, the hiding the gun, that is how she became party to a crime after the fact.
Well, with the theft, I see, but criminal damage to property, where's your argument there?
So the reason I had to charge the complainant is he shot the deer, he cut off its head and left the carcass of the deer at the Whitetail farm. The head itself is not worth thousands of dollars that he took. It's worth maybe hundreds of dollars. It was like a 60-point buck or something outrageous. So they actually stole the head. That's theft. The reduction of the value of the deer, which counts as property under Wisconsin law, was the $15,000 because the carcass is meaningless. People
Again, I'm turning to Terry Wolf and the argument as it relates to the criminal damage to property as a party to a crime, either before, during, or after the fact. How is this the state supporting that argument in a criminal complaint?
The argument is purely that she be helping him evade catch for the entire hunting thing by saying, change the boots. She doesn't want him to get matched with boot scenes at the crime because she probably doesn't know the specifics of how he did the hunting. He just sent her the photo.
But how to the criminal damage to property?
Because the crim damage and the theft were the same act. They were two separate. It's how we had to charge it to explain, because they stole the head. They reduced the value of the deer by $15,000 to $20,000 by killing it.
Are you saying that she knew and was a part of this prior to the action?
No, I don't think she knew about it when he did it. I think he sent her the photo. She became aware of it. And then when she learned from law enforcement, she helped him evade capture, accessory after the fact. if you don't participate in a crime from the outset, but someone comes to you and said, I committed this crime, and then you help them evade capture, evade getting caught, that makes you accessory to the crime. That's aiding and abetting.
Ms. Thompson?
Everything the ADA is talking about is after the fact. There's no information that Ms. Wolf knew about the theft, the criminal damage to property until several days later on a phone that may or may not have been her. It may or may not have been her texting. It could have been anyone in her family or other individuals. We still don't know who that person could have been. There's nothing necessarily that I've seen that's actually connected her to that. And again, her making suggestions about what he should do, I don't see how that's participation even after the fact of the theft and the criminal damage to property.
Thank you.
And just short response to that, I am agreeing. All of our evidence that she became accessory after the fact. She wasn't involved in the actual poaching. She became aware of it later. What I'm saying is when she became subject to that search warrant, because they went to her residence with that search warrant, she got handed it and told what they were looking for. Then she used that knowledge to help Wesley evade capture. That's what we're saying.
I don't need anything further because as it relates, I've read the criminal complaint multiple times. I've read the motions to dismiss. I've read the state's brief and response. I've heard the arguments here today. I understand where Mr. Moustakis is coming from as it relates to his argument, as well as Ms. Thompson and the deer. But here, this is the initial four corners. This is there just enough? Was there probably, this crime did probably occur? And did Mr. Wolf probably do this? We are not here to go anything beyond the first little jump to see if we can even get to court. And all of these facts, all of these arguments, that's better left for an argument to either a jury or in a preliminary hearing stage. Not in this four corners do we have the first little hurdle stage. So as it relates to Wesley Rail Wolf and both the criminal damage to property and the theft, I am denying the motion to dismiss. There's more than enough here to find the probably in all of the connections with all of the facts and all of the information that is contained in the criminal complaint. As it relates to Terry Wolf and the arguments there, I do understand and see the arguments from the state as it relates to the theft of the property and the resisting or obstructing the officer. Theft after the fact as a party to a crime, I can understand that. I cannot find, based upon the criminal complaint or in the state's brief or even in the argument, how I can connect criminal damage to property and how that can be an after or a party to a crime after the fact matter. I'm trying to hear the argument, but even knowing the criminal complaint and hearing the arguments and reading all of those text messages, there's no way I can find that she was probably involved in at any time as a party to a crime to the criminal damage to property. Therefore, I am granting the motion to dismiss count 1 in Terry Wolf's, and I am denying the motion as it relates to count 2 and count 3. Now, if there's a request for reconsideration, I would need to have multiple cases that would show that there could in fact be a connection, but based upon what I have and what I've heard, I cannot find that Ms. Wolf, that there's even that probably to go over the hurdle as it relates to the criminal damage to property. As to the theft and to the resisting or obstructing, there's more than enough there. So now with regards to at least Mr. Wolf, Rayo Wolf, we do need to set a preliminary hearing.
I do have my calendar up, Judge.
Okay. Let's see, where's the calendar? And then we will need to set a status for Ms. Wolf. Preliminary hearing, is he requesting it within time limits or waiving the time limits?
He would waive the time limits, Judge, is that correct? Mr. Roche, say that loudly. Yes.
I can do September 23rd at 10 a.m. Well, anywhere from 10 until 11:30. I could do September 24th, anywhere from 1 until 2. Is this going to be more than, are we going to need to have more time than we usually do for prelims?
No.
Okay. And this would be an in-person appearance, required in person unless it is a waiver of the preliminary hearing.
What date did you say again?
September 23rd, anywhere from 10 to 11:30, or September 24th between 1 and 2.
I think, Judge, I have about a, let me look here real quick. I have approximately a 3-hour drive to get there. I'm gonna have to say it's gotta be September 23rd. Well, it could be what time on the 24th?
1 o'clock?
Let's
Or
do the
1:30.
24th. Yeah, let's
Okay.
do the
We can
24th
do-
at 1 o'clock, because I think it's gonna take, I'm assuming the state's gonna just put 1 or 2 witnesses on, but the cross-examination could be a little more lengthy. And it's not gonna be a waiver, Judge.
From 1 until 1:30,
I don't think that's gonna be enough time.
1 until 2. And if you don't think an hour is going to be enough time, we have to do the 23rd. You only have 1 hour on the 24th, and I will stop you because I am booked from 2 until 4:45 the rest of the afternoon.
Well, in that case, let's do it on the 23rd.
All right, so from 10 o'clock until noon, we'll just block 10 until noon on the 23rd. And for the record, Ms. Thompson made it by 9:15 this morning, so it's able to be done.
She's in Madison. But I'll be there.
All right, we'll see you on September 23rd at 10 o'clock. You have the rest of the morning as it relates to Ms. Wolf and a status hearing. What are you thinking, Ms. Thompson? How far out? What do you want with regards to time?
I assume a pretrial, Your Honor. I mean, however you calendar things, I just need time to talk to the district attorney.
All right, I could do, and you can appear by telephone or video
Okay, great,
at
thank you.
that time. Could you do September 24th at 1?
I can't, I'm in Oneida County. I could, is the 23rd still available as a possibility?
I could do.
Oh, you said I could do it by Zoom.
By Zoom,
Oh,
yes.
Yep, I can do the 24th at 1,
All right.
sure.
24th at 1 p.m. Ms. Wolf may also appear by Zoom. All right, bond continues. We are adjourned.
Thank you, Your Honor.
Thank you. We have.